campus of North Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good afternoon, ladies and gentlemen. I welcome you to the fourth in our 6-week series on the topic, Know the Law. I once again wish to recognize the Kootenai County Bar Association and their work in helping us put this very fine series together, and I also want to recognize the attorneys that are representing the Spokane Bar Association. I hope you're enjoying the series as much as we are bringing it to you, and in order to discuss this fourth topic, which is entitled Domestic Relations, I wish to welcome to our program 4 guests. First of all is Idaho Magistrate John Ramstad, Coeur d'Alene Attorney Sue Flamia, Coeur d'Alene Attorney Eugene Morano, and Spokane Attorney Nancy Wainwright. It's a pleasure to have all of you with us.
Thank you, John.
I would also like to welcome back to the program the two people who are assisting me in this series, and I'm very grateful to them. First of all, regular panelist Lou Reed, and also Assistant Vocational Director at North Idaho College, Bob Brown. We'll commence the questioning with Lou Reed.
Thank you, Tony. We have titled this series, Know the Law. And I'd like to ask you just a general question about what are some of the most common misunderstandings in this area of pertaining to marriage and divorce. What do people need to know that they're a little bit misled on now? Can I ask you, Gene, to lead off with that?
I think the biggest problem that people have in this area is knowing exactly what property they have to divide in a divorce, what belongs to the husband, what belongs to the wife, and vice versa. And also the second biggest problem, the second biggest misconception is who gets the kids. And I guess if there's no more emotional issue or no more important issue to people other than freedom or their own freedom in the law, it's the welfare and the care and custody of their children. And that's the two areas that we as practitioners in domestic relations deal with. That is dividing property and
who gets the kids?
Who gets the kids, basically.
Sue, could you add to that, perhaps?
I would say in this particular area of domestic relations, probably more so than any other area, there's more back fence law than any attorney can imagine. And it's always spoken with great authority. And big problems in terms of who owns what and what share each spouse has over the community assets, division of property, and as Gene said, the custody of children and support of children, as well as support of the spouse who is in need of support.
Thank you.
Bob Brown.
You brought up the topic of, alluded to community property. Gene, I wonder if you could, I hear a lot of people talk about community property and separate property and buzzwords like commingling and things like this. Could you maybe give a kind of a summary of how courts look at community property, how it's determined, what it is, and how one can keep property separate if they wish? And then Nancy, perhaps if there are any major differences in Washington law, you could comment when Gene is finished on any differences there might be.
Bob, community property, all property acquired during marriage in the state of Idaho is considered to be and presumed to be community property. That is, there's half to each spouse, half to the husband, half to the wife. And that's the general run of community property. Separate property is all that property that you brought into the marriage and all property that you acquired during the marriage by gift or inheritance or any of those kind of devices, and that you keep separate. If, for instance, you owned a bank account before you were married, and after you were married you started dumping all of your paycheck in there, and your wife dumped her paycheck in there, then those funds would become commingled, and if you couldn't trace them out, as they call it in the law, then in fact your separate funds, which were there before the marriage, now become community funds also. And the way to keep them separate, to answer your question, is to make sure that it stays in your name and don't commingle. That is, throw any other money in there other than that separate money. If you have a job and your wife has a job, which is very common nowadays, then half of what she makes is yours, half of what you make is hers. And that's the basis of community property. It's half and half.
Gee, let me ask you, for example, the example you gave, let's say a person has a separate bank account. They get married, then the wife maintains a separate bank account in her name, the husband maintains a bank account in his name. Together they maintain a joint account. Could we assume that the joint account would be community property, that each of the other two accounts would remain separate as long as they were treated that way by
That's
the two
correct.
parties?
The joint account where they both put their money in is community property, and as long as you do not take any of your wages or any other money that you get during the marriage and put it in your separate account, then the money that was there originally remains separate. But if you take 10% of your paycheck and dump it into your own account, then you're commingling community funds, because remember, 10% of your wages, 5% of that is your wife's. In other words, half of the 10% is your wife's also.
So would that spoil the entire account then?
Exactly. If you couldn't
By
at a
spoil,
later
I mean,
time trace it, if you could not at a later time trace it out, then it would spoil the whole account and make it all community.
Nancy?
The law's the same in Washington. The only thing that Jean didn't mention, and I don't know whether you have it in Idaho or not, is a community lien. You could own separate property, and in theory, the community only. It wouldn't be available to anybody else. Just the husband and wife could come in and say, well, as a community, I contributed so much to the increase in the value of your separate property, and be able to take that portion out of the property. The same problem if you can't trace it, and it gets so commingled, it's just going to be considered community.
I have a question that deals with some people who have a very cautious entrance into agreements, including marriage, and they don't know what's going to happen later. And we've heard a lot about our premarital agreements, enforceable contracts in given states. And Nancy, let's start with you. In Washington, what would you advise an individual if they wanted to set up an agreement prior to marriage of how they would divide property or whatever the issue might be?
Well,
is that legal? Can you do
oh
that?
yes, you can do it. I guess I have a personal problem with that. Part of marriage is trust, and to have to go into a marriage and work everything out, you kind of wonder about how that marriage is going to start. But then also realistically, you have marriages that are later on, or people who do have businesses and have to know that their businesses are going to continue through a divorce if it should happen. I would, particularly older couples who remarry, or providing for children from two marriages. Those situations, I think, you really are foolish not to at least come in and understand what happens to your property. Also, some kind of an agreement if you don't marry, if you decide to move in. That would probably be something.
But what I'm asking is, if you put it in writing and you go through an attorney and get this done legally, that is binding and effective and can protect your property.
Yes, as long as you've divulged it all and you both had an opportunity to talk to an attorney and both parties are dealing on arm's length kind of a situation, yes.
Sue, is this also true in Idaho?
Yes, it is.
And therefore you could just go through the whole process of laying out a contract, what you would or would not have separate or in common.
That's correct. One of the advantages of that is when you come into a marriage with particular assets is to have an inventory of assets so that later on, say 15 years down the line, if there is trouble and a divorce ensues, then you do have your list of assets so that you know which property is the separate property of each person. Another thing you can do if you want to be careful about handling finances is to set forth how you're going to handle the finances of your marital domicile, including contributions into the fact of a joint account, contributions into the joint account, how these expenses will be paid, and so on. So it's, excuse me, they're legal agreements if, as Nancy said, if there's no fraud and if there's no overreaching. If there's a person who is coercing a prospective spouse, then those agreements are challengeable and could be overturned. But if they deal at arm's length, as we say, and if it's a fair agreement, they're fine.
We may have confused some individuals because we're talking about statutory marriage, that is going through the statute provisions and doing it legally and so forth, versus the common law marriage, although I know that's recognized by law too. Would you make a distinction of, or define the two differences and how that might be affecting the property, etc.?
Idaho is one of the states that does recognize common law marriage, which means parties can establish a marriage without going through a ceremony. And there are certain things they must do to be able to prove that there is a marriage, such as holding themselves out as husband and wife in the community to friends and business acquaintances and so on. But we do recognize that. In fact, there was a Supreme Court case not too long ago reaffirming the fact that Idaho recognizes common law marriages.
And that to be 18 years old, is that correct?
No, there's no
age?
restriction.
And there's no time period. In other words, in states in the past, isn't it true that you have to be together 5 years or 7 years and so forth? And that's not true in Idaho before you're considered legally married?
To my knowledge, there's no time requirement. It is a matter of proof. If you end up in a contested situation, whether there was, the question is whether or not there was a marriage, that's a matter of proof. And so the longer the period they were together, the more likely they can prove that there was, in fact, a common law marriage.
Is that the same in Washington, Nancy?
We don't have common law marriage in Washington.
Okay. Lou Reed.
Judge Ramstad, we've been saving you for the questions that deal with child custody, that all-important area. And as I understand it, the attitudes and agreements and arrangements for child custody have really been evolving over the last few years. And is it true now that most of your couples will agree to some sort of joint custody, which is quite different than in the past? Perhaps you can talk a little bit about what seems to be the prevailing mood and what seems to work best in your court.
Well, I'm not so sure I know what works best over a period of time for people, but Idaho has recently created a statutory presumption for or a preference rather, for joint custody. Now that's only a preference, and that doesn't indicate what the court's ruling is going to be if the parties don't agree on it, or if the evidence offered at a trial indicates that one party is more likely to serve as a better custodial parent than the other. But certainly attitudes are changing. I think the populace, the American public, is beginning to believe that joint custody is a better situation for children generally.
Well, what factors do you take into consideration when you're working out a custody agreement?
Well, in Idaho, I think as in most states in the Union, the key words in looking at where the children will go are what's in their best interests. I think things that in common sense would tell the average person where a child belongs are the things the court can and does consider. How the child gets along with each parent, what the child's preferences are if the child is older, if a parent is stable, if he's more willing to make the commitment to care for children, if he has a history of that, things of that nature.
And you are certainly more open to having the father take on the complete custody, if that is.
Oh, I think there's been a big change even before Idaho created its statutory preference, which I think was about a year ago last July. I think the legal community has picked up on that from other states or the experience of other states and has pressed for that and has made some headway for fathers, a lot.
There are lots of custody questions. I think maybe I'll pass along. Bob, are you going to jump in there?
Bob, or Lou, if I might add to what the judge has already said here about the best interest of the children, that's the key word here. A lot of parents come into my office anyway and say, I want the kids, and I feel the kids that I would make a better parent, and you pin them down and say, well, why do you think? Well, because I want them. As this judge, Judge Ramstad, and our other two magistrates that handle these matters in this area have often instructed those same parents. It's not what you want, it's what's in the best interest of the children. And if parents come away from a meeting with their lawyer or from a trial, they will come away with the understanding that they may not be the best parent for the children in the interest of the children. It may be better for them psychologically, that is, for the parents to have the children. And, you know, yeah, I would feel much better, it would make me happier, but frankly the courts, well, they're certainly concerned about what makes parents happy and that everyone's happy. They're going to look to see what makes the children the happiest as opposed to the parents.
How do you, is there some sort of mechanism for working this through with parents so that they somehow understand that if they win, the child may not necessarily win, and that they have to really absorb this? Because obviously this, in the middle of an emotional situation, it's very hard for them to have the right kind of perspective.
And I think, Lou,
do you do this through lawyers or do you do this through
I think
counselors?
that's the only way to do it. I mean, any competent lawyer who practices a lot in domestic relations in this area of child custody is going to, of course, know the law and know it inside and out. It's not that complicated an area of the law. And we'll tell the parents, if they're being honest with them, which almost all of them are, that here's what's going to happen. Give me the fact situation, I can basically predict what's going to happen. And I think it's foolhardy for any parent who is got a custody fight on their hands. That is, they cannot agree where the kids are better off to do it on their own. We're seeing a lot of that is pro se or by yourself divorces nowadays. And in certain cases, those aren't all that bad. If you've been married a couple of years, you don't have any property anyway, you don't have any kids, it's probably not that bad a situation. You throw in the factor of a large amount of property, or even more importantly, children, and you disagree about children, and you are making a very serious mistake by not consulting a competent domestic relations lawyer and finding out what your rights are, and then acting upon them with his or her help.
Bob Brown.
Could I just say one more thing in regards to this particular issue? I have the feeling that this is such a complicated area emotionally, sociologically, and even philosophically. And I always encourage clients to seek help through services that are available in the community, because the courts can do one part of the job, but they cannot solve the long-lasting problems. And I always encourage people to take those children to these individuals within our community to let them get some counseling and some help to understand what's happened to them and how to cope with this trauma in their lives.
Bob Brown.
There's a lot of publicity about kidnapping cases. Let's say where one parent has custody and the other parent, doing a visitation or something, takes the child and somebody doesn't return. I wonder if you would like to just comment on what are the penalties for, quote, that kind of kidnapping the same as another kind? And a lot of people, I know frequently, I've had a couple of students who said that they lost visitation rights. This was an Oregon case where the father kept the child longer than he was supposed to, in fact had to be forcibly returned, and the court in Oregon, according to him, cut the visitation time down considerably from what it originally had been. Nancy, could you comment on this?
Okay, we have custodial interference, which is a crime in Washington. However, one of the problems with enforcing the law is that a lot of times the visitation is loose, and if you can't prove that there was actual time that the child was supposed to be back home, the police are hesitant to act. They say, well, you know, is it really a kidnapping? You didn't really say you had to be home at such and such a time. Maybe they won't. I've always felt that the judges hesitate to punish a parent, like you say, reducing visitation or something like that. Nobody wants to punish in that kind of situation. Even the custodial interference is a difficult case to bring. I understand there's federal law now, but and it looks very nice in the statutes, but I haven't had any experience of how it works. I know you're now supposed to be able to call the FBI. I also know people who call the FBI and get no answer. There is a beginning of a response, but we really haven't seen the results.
I think perhaps one of the greatest benefits custodial parents now have that they didn't used to have, which is cutting down on child kidnapping, is the fact that quite a number of states in the U.S. have adopted what's called the Uniform Child Custody Jurisdiction Act. And more often than not, when a parent kidnaps a child with whom they presently only have visitation rights, their idea is not to get lost in the crowd somewhere, but rather to move to a different state and go to court there and attempt to get full custodial rights to the child. And this Uniform Act, which many states have now, sets criteria that precludes that in most instances. In other words, the child has to be a resident of the state for 6 months, or the child and one parent have to be there, and the court has to find that most of the evidence regarding the welfare of the child is in that state, and the courts now have the authority to communicate by telephone or whatever from state to state to determine where does this lawsuit really belong.
Has Idaho adopted that?
Yes.
Has Washington?
And that is making a difference, I think.
Do the judges have the judges set up the communication now?
I've called Spokane and some of your judges I know.
I
I
know.
think it's pretty common.
I think we want to move on to another area, and Judge Ramstad, I would like to inquire with you concerning really two parts. And first of all is another thing that comes up in divorces and is a great concern, and that is financial settlements as far as child support and alimony. Since you deal with this so much in court, could you give our viewers some idea of what kind of criteria the court looks at in determining, one, whoever gets custody of the children, what kind of child support there will be, what percentage of the income of the other spouse? For example, if the mother gets custody of the children, what do you use as a criteria to determine what is reasonable child support from the father? And secondly, in alimony. Again, if it's the wife asking for alimony, for example, what kind of criteria do you look at to determine what that would be, if any at all?
Basically, on custody, your starting point is to determine what it's cost to support the child historically. You divide out the child's expenses from the general family expenses. You take a portion of rent, et cetera, and you come up with a figure that historically it's cost to support the child. And what our Idaho statutes, and I presume it's pretty much the same in most states, is that you take a look at the relative estates of the mother and the father. You take a look at the relative earning capability, and you make a decision to apportion the cost of raising the child on that basis. And that's basically where child support is worked out. I think there's a problem that I think a couple of the attorneys have mentioned with do-it-yourself divorces, where people accept what they've heard as appropriate child support and settle for that in do-it-yourself divorces, instead of getting, even if they want to do their own divorce, perhaps getting some professional advice on where child support ought to be. I think a lot of people are getting, or a lot of custodial parents are getting underpaid. Turning to alimony, excuse me.
Oh, go ahead.
Turning to alimony, which Idaho now calls spousal support, by statute that's only available in Idaho if you prove fault, grounds for divorce which include fault. Although I think when that new statute gets tested, we'll find that it's, I suspect that it doesn't mean what it says. I think you'll be able to get it without fault. But basically by statute, alimony or spousal support, the idea of the statute is to provide support for a spouse that has less earning capacity or little earning capacity, usually herself. It's usually the wife that's asking for it, or is old or is infirm so that she can't go to work. And the idea of the support is either to support her according to the ability of the husband to pay until she can either become employable through training or perhaps all the way down the line if she is simply not trainable or not employable.
Some viewers might be confused, if they've not been involved in this too, that both in child support and alimony, if the economic condition of the person paying that changes, they lose their job or have to go on unemployment and so forth, that can fluctuate and go up or down depending on the financial prosperity or lack of it of the person paying. Is that not correct? If they come back into court and ask.
Not only child support, but child custody. The court always, in Idaho, at least in most states, retains jurisdiction over those two particular issues, and either party, whenever they feel it's appropriate and feel they can show a substantial change that should result in a changed court order, can come back to court and make application.
Thank you. Lou Reed.
Are the laws in place that you as lawyers need to represent your clients well? Sue has alluded to the fact that the law, of course, is not going to solve all the problems in this particular area. But are there any new statutes or any reform that you feel are in the wings in either Idaho or Washington to smooth out your way?
I don't know of any that are in the works right now. I know one that a lot of us feel should go, or at least I do anyway, whether Sue agrees with me or not in Idaho, is this idea of fault in order, as the judge has just alluded to get spousal support. I think frankly, I think it's a stupid law. I think it forces people to drag in their dirty laundry and establish fault, mental cruelty, adultery, whatever it happens to be, when it's not necessary. It should be that if the spouse needs the money, then come in and establish that the other spouse can pay it, and then let the judge decide whether he'll order it or not. Otherwise, you got to come in and say, oh yeah, she's sleeping around with everybody in town and so on and so forth, and it makes it very messy, and frankly the judges don't like to hear it, and we don't like to bring it up.
And it doesn't mend the marriage. It doesn't solve any
doesn't do anybody any
problems.
good. Doesn't do anybody any good, and I think eventually our legislature is going to have to address it and change it.
Do you agree with that, Sue? Is that?
I think it should be amended, definitely.
And how about Washington, Nancy?
No, we don't have fault. Well, other than if you would come in and start saying that the money was being spent on someone other than the wife or the husband. But that would be just that particular situation. In order to obtain maintenance, you do not have to prove fault. The only area I would like to see more enforcement is in once you have got the support order, is being able to get the support.
And there are problems across state lines, and there are numerous problems.
Yes, there just
but
are.
And does that take federal legislation almost to address that question?
I understand the federal government is starting to get involved in that there's talk about holding back income tax refunds for people who are delinquent in support payments. I would like, you can now garnish paychecks that you didn't used to be able to garnish, military paychecks and federal employee paychecks. But the more we can have along that line in order to enforce the support payments, the better off we're going to be. A support payment is not very good to anybody when you can't get the money.
Bob Brown, we have about 2 minutes.
Okay. Gene, well, I know you had some work in this before. What can be done now? Nancy's indicated that some of these things are in the wing. What can a parent now whose spouse, ex-spouse, is delinquent on child support in Idaho, what can they do?
Okay, they can execute against any assets that particular spouse has, and all that takes is a writ of execution, which is relatively simple to get. And they can, as Nancy has indicated, guarantee paychecks. Here in Idaho, we can take up to 65% of the non-paying spouse's paycheck each and every time he or she gets a paycheck. We can also take all of the property that they own almost without exemption, except for a homestead exemption and some very minor exemptions. And most of them don't apply if it's child support. They can also take that spouse back to court for contempt of court. And our judges have the power for non-payment of child support to order the non-paying spouse to jail for 30 days. And frankly, I've seen this judge here and other judges do just that, to jail for 30 days. Frankly, it's very effective.
I must interrupt. We're out of time, and I want to express appreciation to all four of you and to the panel for a very informative program. Ladies and gentlemen, I hope you've enjoyed our program and that you'll be with us again next week when we will do program number 5 in this 6-week series. And at that time, we're going to be dealing with wills and estates. I'm very delighted with this series. I hope you're enjoying it, and we'd like to hear from you. And you can give us your ideas by writing to me at North Idaho College. Please have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.